Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about Elections Act rules and campaign donations. Cases that should have gone to the Supreme Court of Canada, but didn't. Ms. Meho was convicted of giving a donation that was larger than the amount she was permissibly allowed to give to a political party. A prosecution was commenced under the Elections Act, and she was ultimately convicted of the offense. In the scope of the prosecution, Ms. Meho challenged the constitutional validity of the section that she was convicted under, as well as several other sections of the Elections Act, arguing that they were unconstitutional and of no force and effect. Her challenges were dismissed, in part on the basis that she hadn't brought her challenges before a specialized tribunal designed to deal with these specific challenges. Additionally, some of the sections that she argued were unconstitutional were not sections that affected her, and so she didn't really have standing to challenge them in the context of the case. This leads to an important question that the Supreme Court of Canada should have considered. If these are rules that govern how elections take place, part of the most important democratic process we have in our country, we need to know that they're constitutionally valid and not infringing on the rights of individuals. It is an important issue of public importance that it be decided whether or not these provisions are constitutionally valid. And if somebody is in a position to have enough standing to challenge one of them, why should they not be able to bring in other sections when the issue is squarely before the court in those cases? And does limiting the consideration of constitutional issues to specialized tribunals not dilute the power that courts have to decide the Constitution? The courts that are enacted under the Constitution should have the power to decide those issues. And yet the Supreme Court of Canada sort of missed the opportunity in this case to see how these things relate and to make it easier for citizens who are affected by laws to bring challenges to test the constitutional validity of those laws. It shouldn't be that this is only a privilege that an Attorney General of a province, a person who is elected under an election held pursuant to the Elections Act, gets to challenge. It shouldn't just be somebody who's affected by the law once they're prosecuted because of a violation or alleged violation of it that gets to challenge the law. In an election, any adult citizen of Canada should have the right to challenge a law that governs what they can and can't do as a person who wants to contribute to a campaign or participate in any meaningful way beyond voting in the election. And this is an importantly timely issue right now, given that we are in the midst of a federal election in Canada. And so the Supreme Court of Canada had an opportunity to clarify things in this case at a time that would have affected the very fabric of our society at this moment. And unfortunately, they missed that opportunity. It's a shame that they didn't take the chance to hear this case and to decide this issue, because your right to participate in your democracy is one of the most important Canadian values that we have. It is a matter of public importance, national importance, the type of case the Supreme Court of Canada should have, and unfortunately didn't hear. You're watching Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull for putting together these videos. Like, subscribe, and share with your friends.